Ladies and gentlemen, if you would please bear with us, for we are already, frankly, we're just waiting to hear whether the Archbishop will be here with a few minutes or not. And I do hope that you are not bored too much or offended for waiting a little bit.
The judgment set aside, we had a hearing, they failed, and having failed, we had the opportunity to come and register the judgment in England. In the meantime, they appealed in Cyprus, so the case went to the Supreme Court, and they were not successful there either. We registered the judgment in England, and we had a hearing in June or July 2006. I'm sure you'll know that we were unsuccessful, and the judgment came out in September 2006. We appealed. The appeal was tried in, or the beginning was in June, I think, 2007. We were successful at the appeal in the sense that the case was referred to Luxembourg. The reason that the case was referred to Luxembourg was that it has to do with primary European law, with a regulation that had never so far been interpreted by the Luxembourg Court, which is the Supreme Court in the European Union. We had a hearing back in September 2008, and the judgment came out a month ago, 2 months ago, in April, and I'm sure you all have heard about it. It was a sound victory for Mr. Apostolides. We're very happy with it. It was, I say it was 140% success, in the sense that 5 questions were referred to the court, and in the end we had a reply regarding 7 points instead of 5, and Mr. Apostolides was successful in all 7. The judgment of the Luxembourg Court is binding in all European countries, and now the case is back in London. Hopefully we'll get a hearing date soon, and we hope to have judgment sometime later on this year. I would like to stress, though, that even though we hope that we will be successful, and the final outcome will be a victory for Mr. Apostolides, it should be stated now that it's not the end of the road, and one shouldn't be, well, we shouldn't count our chickens before they hatch, let's put it like that. One of the things that I've been hearing about the case, and they're not correct, it's not correct, is that the court in Luxembourg has reaffirmed the property rights of Greek Cypriots in the occupied north. This is not the case. Property rights in the north of Cyprus, first of all, they do not need to be reaffirmed. They have been, they're there, they've been established by the Dina Boizidou case, which is a landmark case, and that was not the issue here. The issue was whether a judgment of the Court of the Republic of Cyprus can be enforced in European countries, given the fact that these judgments relate to land that is found in the occupied north. It's not a matter whether Mr. Apostolides is actually the owner of the land, but whether we can enforce that judgment. Now, it's a very sound victory because it has made legal history. It has made legal history in the sense that now the courts of the Republic of Cyprus can make judgments about any civil or commercial matter relating to the north, and then that judgment can be enforced throughout Europe. It is very important and very beneficial for our Turkish Cypriot compatriots, in the sense that, and I'll give you an example, if a Turkish Cypriot enters an agreement with an Italian firm and then at the end of the day, the Italians default or damages need to be paid to the Turkish Cypriot. Now the Turkish Cypriot can file an action against the Italian firm in the courts of the Republic of Cyprus and have the judgment enforced in Italy. Whereas in the past, Turkish Cypriots did not have access to the courts and to European justice. So it's beneficial for everyone in Cyprus. We are very happy that in this way we have created an instrument which can be used for the benefit of those people who own property in the occupied north, and that property is being trespassed upon by people who have property within the European Union. I will be very happy to answer any questions that you have. I'm trying to be brief, and I look forward to your questions. Thank you very much.